We begin our report with a call for order in the court. President Biden Monday suggested a list of reforms to the Supreme Court. In an op-ed for the Washington Post, he criticized the conservative justice's recent decision to grant presidents immunity for official acts and cited what he calls a crisis of ethics. Biden wrote, quote, "We can and must prevent the abuse of presidential power and restore the public's faith in our judicial system." He suggests three changes: a constitutional amendment limiting presidential immunity, a binding and enforceable code of ethics for justices, and term limits for Supreme Court justices who currently enjoy lifetime appointments. President Biden spoke about his proposal Monday while commemorating the 60th anniversary of the Civil Rights Act.
The court is not self-policing. The court is not dealing with the obvious conflicts of interest. We need a mandatory code of ethics for the Supreme Court, and we need it now.
And Jed Shugerman joins me now. He's a professor at Boston University School of Law. Jed, let's start with this immunity, the constitutional amendment. Is that realistic or even a practical suggestion, do you think?
Well, just a reminder that it takes 2/3 of each house of Congress and then 3/4 of the states. So it is not at all realistic that a presidential immunity amendment will pass anytime soon. But it is good politics. And there is a slight chance that if Trump loses and that we have President Harris, some number of Republicans to get to 2/3 might say, hey, we actually like the idea of keeping checks and balances on a president. I don't think that chance is high, but it's possible.
All right, I want to spin through some of these others, even though I've got a follow-up on that one. But let's go to this ethics problem question. How much of a problem do the Supreme Court justices have? Is the problem that they have that there are specific ethics clashes? So, for example, Justice Thomas, his wife was involved, at least at some level, in an effort to overturn the election. Or is the ethics challenge a general mindset that various justices, some more than others certainly, have operated as if they're sort of got their own set of rules?
I think the attention on this is triggered by the recent scandals with Harlan Crow and Justice Thomas, as well as Justice Alito. And it's not so long ago that Abe Fortas was attempted to be elevated to replace Earl Warren from an associate justice to a chief justice. And a much more minor ethics scandal meant that he had to not only withdraw his name from that chief justice appointment, but he had to resign from the court. And that was over a much more minor question of ethics. So that was just 50 years ago. So a lot has changed in terms of the idea that the media or that public opinion can be a check on the justices. I think there's a real sense that the justices don't really care about public opinion, that they care about a base, and the base doesn't really care about this.
And the Abe Fortas nomination by a Democratic president late in an election year was, of course, blocked when President Obama tried to do the same thing, another norm that has shifted. Let me ask you about term limits. This seems legitimately interesting. When the court was formed, justices didn't live as long as they live now. The court played a different role in American life. How do you see the question of term limits? And not necessarily, well, A, is it wise? But then B, how has it changed with respect to the origin of the court?
Well, first of all, I think one pivotal change is that up until about 1970, the average justice spent 15 years on the court, which is less than 18, just to do some basic math. Yeah. What changed after 1970 is with health care, enjoying national health care, the justices have now served 26 years on average. For example, Scalia and Kennedy served about 30 years. Roberts and Alito have been on the court for almost 20 years each. So I think that this is partly a response to this being a recurring issue of just about how long justices are serving. I think the second thing that's triggering this is less about the term limit length, how long the justices are serving, and how justices manipulate the retirements when their party in power or when their president comes back into power. So again, a little bit of history here. There was reporting that Justice O'Connor, when she was watching the 2000 election and it looked like Gore was going to defeat Bush, she said privately, "Oh no, I can't retire." lo and behold, a month later, she is part of the 5-4 decision that puts Bush into office. And then lo and behold, not in those next 4 years, partly because I think she was chastened by that revelation, but she waits until 2005 when Bush wins re-election. So that's one example among many. Kennedy retired right when he was promised there were some conversations behind closed doors. And so I think part of what the proposal is aiming towards is a regularized appointment that every 2 years there's one appointment and every president gets two. That's the best part of this proposal. I think there are many problems with it, but I think that's the part that deserves commending.
Jed Shugerman with Boston University Law School, thank you so much for being with us.